get some wins and high ROI return edits to address some risk and make sure that what they're paying is what they wanted.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Florida attorney Arthur Baker tears down a standard corporate lease agreement from Amerx Healthcare Corporation. Arthur points out where a corporate tenant has leverage in these standard agreements and the due diligence needed to make sure your client's use of a space complies. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose of this show is exactly what it sounds like. We take contracts and we beat them up. We're mean to them occasionally, nice, but not often, because that's not as funny. I hang out with smart friends like Arthur Baker here. Arthur, how are you today?
I'm fantastic. Thanks for having me.
I am excited. Excited is overselling it. I am interested in this subject that we're talking about because we are talking about a document that I feel like probably comes up a lot for attorneys that are sort of doing general practice-y things for their clients, and it's this. I'll share it with you guys. This is a standard lease agreement. We're pulling this one from Law Insider. This is from a healthcare corporation, so there are some things that are specific to this. But before we dig into it, Arthur, what is this document? When are lawyers going to see this thing?
Yeah, well, thanks, Mike. So it's not every day and not every company that needs 1 million square feet of an office building, a couple stories, or a giant warehouse. But there are a lot of companies and businesses that need 10,000 square feet, an extra suite in some framework. And a lot of times they don't think they have much negotiation leverage, and they may not. But because of that, a lot of times they don't have anybody take a look at the lease or really thoughtfully think through, does this lease really work for why I'm signing it? Should I be paying money for it? Does this make sense? So I want to take a look at this, go through a few items that I think are real practical tips to help businesses that are looking at smaller leases get some wins and high ROI return edits to address some risks and make sure that what they're paying is what they wanted.
Cool. All right. Well, before we do that, tell the people at home about yourself. What's your background? What brings you to documents like this?
Yeah, thanks. So I am the managing attorney and president at Concord Advantage Legal. We do a lot of general counsel services and commercial real estate transactions. I do a lot of these tenant rep office leases for clients, primarily throughout Florida. And in my general counsel services, I help a lot of businesses of all shapes and sizes work on their workflows, process building, compliance, and day-to-day transactions. I also teach at the University of Miami School of Law a transactional skills course, helping students learn some day-to-day practical contract teardown reviewing and helping clients get value for the services.
Gosh, going to that law school, as an aside, was the last pre-pandemic conference that I went to. I went to something for the Miami-Dade Bar and spoke at it with our friend Jane, who is the president now of the bar there, I think. Anyway, it was wild because, they were all handing out waters, like the workers there were handing out the waters, but you couldn't touch the doorknobs. There was this, it was madness. That was the last pre-pandemic thing that I've been stuck at home for a long time. I'm very lonely. But fortunately, we have the power of video. You see that pivot from my bad therapy session? And we can talk to each other about documents like this. So what we are going to do is run through this lease agreement. I don't know how standard this is. We'll talk about that. But I want to start you, Arthur, in 3.1. Under 3 talks about the use of the premises. There's a lot to unpack in 3.1. Talk to us about that section.
Right. Yeah. So looking at Section 3, they address a lot of the different components of the use of the premises. And when you're a tenant, you want to think of it in a couple different ways. First, thinking of how is the landlord limiting my use under this lease? And then also thinking through how else my use might be limited from zoning or other sort of framework. So starting with how the landlord's limiting your use, you can see in the first sentence of 3.1 that it describes the premises being leased for the purposes therein of a medical supply business. Pretty vague. Do you know what a medical supply business is, Mike?
Could be. I've seen Breaking Bad. It could be something. It could be a drug dealership for all I know.
It could be. And so we don't really know from just an optical view here, are they making and molding prosthetic limbs? Is it just a supply framework of a bunch of gauze? Is there heavy manufacturing that goes into it? If there's headquarter employees or other staff there, is there any office space that's a component of it? We don't really know. And that use limitation can be a little compounded complication when you look at the end of that second sentence of 3.1, where it talks about the lessee may, upon the express written consent of lessor, which may be withheld unless there's absolute discretion, yada, 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 uses for other lawful purposes reasonably similar to the aforesaid operation. So in short, what it's saying is you can only use the premises for what I said in the first sentence. And even for reasonably similar items, you have to get my approval, which can be withheld in my sole discretion.
Yeah, I would assume this is a debated point. Like if you're whether you're the drafter or the other side of this, would you prefer? This is like specificity that isn't, right? It's almost the illusion of specificity. Do you think it's better practice to have like you can operate any profitable business with an office environment or whatever? Like why do this industry specific thing? Who does that advantage?
Oh, and unsurprisingly, it's the landlord's advantage. And, I represent a lot of tenants. And prior to opening my law office, I was in-house for a global real estate services company where we had a lot of tenant rep brokers. So I'm very passionate for my tenants and tenant brokers. So unsurprisingly, the landlord's form is very narrow. They have a reasonable framework of not wanting you to have a Ringling Brothers circus or a tattoo shop or a pornography store, or everything that may not necessarily jive with some of the other tenants or their goal for the property. But having overly restrictive uses, again, medical supply business, if it was the office framework for that business, the lease doesn't expressly allow that. And I think the landlord's base form goes a little bit more overbroad. So from a tenant's perspective, obviously we want to have very broad uses. A typical edit that I would typically do is try and describe and talk with my client of, well, what are you really doing? Are you making prosthetic legs? Is there a lot of storage components here? Is there back office? And I like to have that description and then include and ancillary uses. So ancillary uses, we shouldn't have to be coming back to the landlord to, may we add a break room for the workers? As long as it's within the confines of the building, consistent with zoning and all those other items. So,
well, and I know there was a connection to 12.1. Like, what's the relationship between this one and 12.1 and when you start subleasing?
Right. So, thinking about it, real estate can be a large capital expense for a lot of businesses, even in some smaller leases like this. You may have your business go in a different direction. You may currently be manufacturing gauze and supplies, but you may pivot into making those prosthetic limbs. That gets a little bit more complicated. You may have too much space initially, and you want to sublease to a sporting goods manufacturer, a contact that you have, to help save on some of the costs. Or you may just want to assign the lease entirely because maybe you're moving to a different location or some other framework. And because these are private rights that go with the parties to the agreement, if you assign this agreement to your sporting goods manufacturing friend, but the use was still limited to medical supplies, that would be a little problematic for your sporting goods friend. May not be a friend much of after him getting that lease.
Right. Yeah. So, the difference in the language between those two sections is a bit confusing. You had mentioned that this is all part of this question of, is the landlord limiting your use, but you mentioned in preparation that there's this second question here of, are you doing what's required to make sure that the premises are good for use? So talk to me about that question and what 3.1 and 3.2, the guidance that gives in terms of your use as the tenant.
Yeah, certainly. So if you look at the first sentence or the second sentence of 3.1, where it talks about the lessee has inspected the premises and has satisfied itself that they're acceptable, subject to completion of lessor's work, which we'll get into in a second. So when you sign this lease, you're saying, I've looked at it and everything's great. Even if we get some broader language of the ancillary uses for this medical supply business, if zoning doesn't allow the manufacturing and some of the heavier industrial uses that you intend to use,
Right.
you still can't use that property for it. If the configuration of the building, say you have a high volume business of, let's just stay on these prosthetic limbs. I don't know why we're there, but we're saying there, you're moving a whole bunch of legs
Right.
and you've got trucks that are going to be coming in and out of your business all the time.
Right.
Is there a loading dock that is sufficient? Are we going to have, 18 wheelers coming through? What's the actual framework and logistics for getting access to the property? Does it work? A lot of times I'll be helping clients all over the state of Florida. So Google Maps is a big friend of mine. Obviously the data isn't always most up to date, but it helps me take a peek at the building and get a general understanding of where am I, what's going on, to get us back to that key baseline question of, does this lease work? So when you look at the building, it's a one-story building. So I'm less concerned if I had issues going up and down stairs or needed a special elevator. Well, it's a one-story building, so I'm less concerned of whether that's going to work or not. And it's just important that, especially on these leases where the tenants don't have, and the landlord may not be as willing to listen to that many negotiable points, for you to do the things that you can on your end and the proper diligence to make sure that the building works. So we don't need the landlord to rep that the building is zoned for XYZ. If we feel confident, and the tenant working with an attorney like myself or others, in our assessment and other frameworks. Similarly, in how the zoning and the landlord, those concepts still work together, is typically we want to have some kind of representation and warranty from the landlord that they're not going to rezone the property while we're there or cause some changes that would inhibit or make illegal our use, or make any changes such as build outs or other frameworks that would prohibit our use. So if a big sell for us was having that access with back loading docks so that our trucks could get in, but the landlord decides to make it all guest parking in the front framework and adds a little Zen garden in the back where we used to have our trucks, well, we want to have some of that protection. So just making sure that the landlord doesn't change it when we have it. So a lot of the things that we'll typically push for, and I think is fair, is that the landlord reps and warrants that it's suitable for your use as of the commencement date, at least.
So then what's this, I'm looking at the second sentence in 3.1 that talks about the completion of the lessor's work as the condition that the premises is acceptable. What's the relationship with that and the landlord saying it's done? What is the completion of the lessor's work?
And that's a good question. So when I look through the lease, interestingly, you don't see many other references to what this lessor's work is. And that can be problematic. So if you looked at the building and a lot of these warehouse distribution uses, you might have some shelving that's going to be installed, some the loading dock maybe being built for you or being adjusted. So it's important for, does this lease work? Meaning, what is it going to take from signing this to when I'm using and occupying it and selling my prosthetic legs to get it to work? And usually you'll describe in more detail what that work is. And when I looked in this lease, I noticed that it deals with in 4.1b, it talks about an office build out payment, as well as 4.1e. That's over $100,000. So it deals with the payment aspect of some build out, which presumably is that work, but it doesn't deal with what a tenant usually wants to be concerned of. What's the quality of that build out? When is it done? Because if you looked at this, I see that it's a January signing date and a May commencement date, roughly. So in those 4 months, is that work going to get completed? If it doesn't, there's no real ramifications or rights that the tenant has here. Especially in the market now with industrial and office leases and some of these distributions. I mean, these aren't staying on the market very long. Their supply is very low. So if you're in desperate need as you're expanding your business for some space, you may not be wanting to wait 3 months for a delayed build out, 6 months, a year. Usually it's helpful to have some back end walk away time period or some right to recoup that payment, however it is. But when you look at this, it doesn't really provide much detail on that.
Well, I know you are familiar with Linesider's functions, including the common contracts function. And as you look across at other contracts that are trying to accomplish similar things, what do you see that might be better incorporated in this agreement? What kind of differences are you saying that matter?
Yeah, and it's good you brought up that function. It was interesting on this lease. There was another common contract listed for the adjacent property with the same tenant and a similar landlord entity. Again, I don't know the specifics of this deal or other framework, and as you know, the facts and what was really going on are really what's important. It's easy for us to call shots from the balcony on what's perfect, right, or wrong, but looking through it, I was able to compare that lease to this lease and notice that their standard form was used and there is no build out concept or lessor's work, which is fine and good and would make sense in that lease. But there, as I've seen, especially in some of these smaller frameworks where people may not have sophisticated counsel or just may not be putting the effort into the deal because it's smaller on either end, not really realizing that that standard form works when there isn't a build out component, but in this framework may not, and could have just been added as a one-off line saying, well, the payment's due, but the tenant doesn't really have much protection here from that.
I'm scrolling down to 20. This is a very specific. I've worked in a warehouse environment before in one of these strips in Austin, and we moved hazardous materials when I worked for this freight forwarding company. There's a specific section in here in 20 about dealing with hazardous materials. What do you think about this section in 20?
Yeah, so to give the viewers a little overview, especially in industrial and warehouse, there's a lot of environmental concerns. Start thinking of dry cleaners. That's the typical example that everyone worries about. And when I check the zoning and other framework, dry cleaning is a permitted use. So there may be a dry cleaner adjacent to this unit in the same building, whether it's owned by the same landlord or not. But the environmental impact and cleanup costs under some federal regulations and laws can be astronomical. Just ballparking the remediation and cleanup of some of the dry cleaners impact can be up to $500,000, depending on when the remediation is identified. Unsurprisingly, we don't typically find these environmental issues the moment of the first drip. It's usually years down the line, and the deeper in the earth that it goes, the more expensive it can get. So looking at this contract, it's important that we're not signing a contract that's putting us on the hook for some big liabilities just at signing. So it's fairly reasonable, and some of the typical carve-outs I have are to at least have the landlord represent that there's no hazardous materials or contamination as of the commencement date, and to at least carve out then our indemnification obligations to issues that are already there before we moved in or items that were caused by the landlord or others. You look at section 20 and it talks about the indemnification here as being acts or emissions caused by the lessee and occurring during our occupancy of it. But there are things that can be caused by other parties that could be arguably blamed on us, or it may be less certain of the causal framework on that. So it's very important, especially in these smaller leases, that you're not signing on to a massive liability from the front end. And again, when trying to negotiate these landlords, I've had fairly good success of talking through these reasonable points. And rather than redlining the whole document with a material here or changing discretion framework there, just having a few carve-outs that properly address these high-level risks. Yeah,
you only got so many conversations you can even have with these guys. All All right, take me to 21. You had mentioned that in these kinds of deals, all kinds of people are being paid and money's crossing each other. What do you think about the broker section on 21?
Yeah, so looking at 21, for those who may be less familiar, unless the lease provides differently, in Florida, the landlord's responsible for paying a commission. And a lot of times, unsurprisingly, in landlords' leases, they'll make sure that their listing agents, the landlord's broker, is stated, gets paid. Tenant rep brokers, unsurprisingly, are pretty good at making sure that their name is addressed in getting paid in a framework. But what's important, thinking through this example again of low supply, a bunch of prospective tenants maybe taking a look at this, there could have been a bidding war for the space.
Right.
You don't want some claim of other prospective tenant brokers that they helped affect the deal and have some right to some commission that's owed as a result from the transaction. And when you look at the wording of Section 21, I typically like a clearer statement of the landlord is going to pay the commissions owed under this, under a separate agreement. And 21 here is silent on that payment framework. It talks about, the only other real estate broker involved was this entity, and that will each indemnify each other for any other claims arising out of it. But breaking that down, there can be finders. They may not have been the broker on the deal, but again, those that have a procuring cause argument, which in Florida, if you help bring a ready and willing and able buyer tenant, it doesn't matter that the deal transaction doesn't necessarily close the signing of that lease. If you brought them ready, willing, and able, you could have a procuring cause argument there. So it's important here just to make sure that everyone's taken care of and there's no surprises on the back end where the tenant's broker gets stiffed, where there's claims coming from other potential brokers, and we don't leave some of those payment obligations uncertain.
I'm trying desperately right now in my mind to make a tie-in to the TV show Burn Notice, which was recorded in Miami and is an excellent show where everything blows up all the time. I'm not really sure how Michael and the team on Burn Notice fit into a contract like this, but I am thinking about sort of stepping back from the lessee, which sounds like is your general approach, thinking of just the contracting exercise when you've got people in these warehouse spaces who are doing everything from having an office to, selling drugs to blowing up with old Dodge Chargers. Prescription drugs. Or it's Florida. Anyway, it could be all over the place, right? Do you think this document, from the drafting perspective, was drafted well for the landlord's purpose, or do you think that as this was drafted, it's creating confusion that is going to cause problems for the compliance that they want to happen? Is the lessee looking at this going, "Oh, what the freak I'm supposed to do with this?" That seems to undermine the landlord's purpose.
Mm-hmm. Yeah, I think this document is problematic in that regard. Again, we don't know the exact specifics of the background. We don't know whether this is a market rate. They might have gotten a really great deal on this. They might have made it up on the back end of that adjacent unit. They might be doing some other business transactions where the tenant got a pretty good windfall. So this is how it was. And similar to it can be a trust factor. If you were to have a brother that you had opened a business and you were going to sublease some space to him, yeah, he should still be, from a legal standpoint, concerned of potential hazardous waste and other frameworks, but you're brothers. You're less likely to sue him about it. You're less likely to try and bring a raw deal. But what happens in a lot of these smaller leases is, as you can look through your system, and typical tenant leases, they can be 50, 60, 70 pages, very long, complicated documents that most tenants don't read in full detail as well as they should.
Sure.
So unsurprisingly, with a shorter lease like this, there are components that are left out. So as a base standard process, it's definitely missing a lot of key items that I would typically look for. But that might have been some of the deal and risk assessment here. I think it's, especially in these smaller transactions and dealing with tenants, just helping clients make an informed decision. So if the landlord is won't even address any potential negotiations or any reps, just knowing, well, maybe I can spend $2,500 on a environmental phase one to see if there's any of that crazy stuff there, and then to feel more comfortable moving forward, and then make it a risk assessment as opposed to just signing, as is, because as we found out in COVID, when everyone's making money and everyone's doing well, everyone's happy.
Sure.
But when things get tight and the business might pivot necessarily, and now their use may not fall within a medical supply business, or the landlord is going to not approve any other use because the supply of similar property is so low that he'll just boot them out and get up another tenant at a higher rate.
Gosh, you really do imagine these landlords sitting at home, all the stuff they didn't care about before, but now they're surrounded by their kids yelling at them while they're trying to work. And it's like, okay, now I'm going to get really upset about 7.3 and dig into that. Well, we will have this contract at lawinsider.com/resources where people can look at it and get an idea of it and some comparable contracts. So I appreciate you sharing it with us. Also on there, I want to include your contact information. If people want to reach out to you and learn about your practice and your work, what's the best way to connect with you?
Best way is probably just on LinkedIn. You can search me out, Arthur Baker, again, at Concord Advantage Legal. LinkedIn, it's where all the happenings happen. It's how we connected too. So
LinkedIn. Oh, I could rant about that. Okay. Well, I appreciate you showing up and having this conversation about the leases. For any of you who want to join the show and tear down a contract like this, just email us. We are at community@lawinsider.com. Arthur, thank you again. We will see you guys next time.